Several progressive groups trooped to the Supreme Court as the SC begins oral arguments on the anti-terror law. To tell us the latest on the ground, we have Dale De Vera. He's reporting to us live from Taft Avenue in Manila. Good afternoon, Dale. What do you have for us?
Charles, after getting postponed and even one attempt to cancel the oral arguments on petition against the anti-terrorism law, it is finally happening this afternoon. Even before it started, several groups joined together to show support for the petitioners who are set to attend today's Supreme Court session. Earlier today, a group of students held a protest action at UP Diliman to what they say is to push back an attempt to obliterate democracy. The group says they also condemn the tagging of several universities in the country as breeding place for terrorists. While here in Padre Faura, groups including lawyers, lawmakers, and laborers have gathered as petitioners prepare to enter the High Court and participate in the oral arguments. Even COVID-19 was not able to stop them from challenging the Republic Act 11479 or the Anti-Terrorism Act of 2020, which took effect in July last year. The High Court has consolidated a total of 37 petitions with 21 issues set to be argued on, though only 7 lawyers from the petitioners will be allowed inside. Among the provisions that the en banc wants to discuss is Section 4 that expands the definition of terrorism. Petitioners argue that under the ATL, advocacy, protest, dissent, or mass action may be considered acts of terrorism, though the government earlier said that it is not intended to restrain rights, particularly freedom of speech and of expression. Section 25 of the anti-terror law is also among the issues that will be argued on as petitioners question why the Anti-Terror Council should be given the power to designate a person or a group as a terrorist, allowing enforcers to bypass the courts. Petitioners also raised the question on the number of days a person may be locked up under Section 29 or detention without judicial warrant of arrest. At present, when the privilege of the writ of habeas corpus is suspended, the Constitution only allows a 3-day detention, much shorter than what the new law prescribes. Recall that a test case has already been filed against 2 ITAs in Zambales. Charles, in less than an hour, the oral arguments at the Supreme Court will start. Charles?
Thanks for that, Dale. That was Dale De Vera reporting to us live from Taft Avenue in Manila.